Digital data is inherently volatile. A single keystroke can alter an email, modify a timestamp, or rewrite a chat history without leaving an obvious trace. Proving that an electronic record hasn't been tampered with is the central challenge of modern trial practice. To address this, the Indian legal system replaced Section 65B of the Indian Evidence Act with the protocols established in the Bharatiya Sakshya Adhiniyam, or the BSA, specifically through the strict requirements found in Sections 63, 64, and 65. This illustrates the relationship between two distinct sets of laws. On the left is the Information Technology Act of 2000, the substantive law. It provides legal recognition for electronic records and digital signatures. But while the IT Act defines what constitutes digital data, it does not provide the mechanics for how to admit that data as evidence in a trial. Mastered the basics? Make sure to hit that subscribe button and turn on notifications for the raviklegal channel, your ultimate guide to navigating complex legal frameworks with absolute clarity. A digital file cannot enter the record simply because it exists in a recognized format. Sections 63 through 65 of the BSA function as the procedural mechanism required to validate those IT Act definitions for judicial scrutiny. These sections dictate the exact steps needed to admit electronic files into court. If a litigator fails to follow these specific steps, the electronic evidence is inadmissible, regardless of whether the IT Act recognizes the file type as a legal document. Navigating this relationship between substantive recognition and procedural rigor is required for any advocate seeking to submit or challenge electronic evidence. The necessity of a certificate depends entirely on whether the evidence is primary or secondary. Primary evidence in the digital realm refers to the original physical device, the actual smartphone, hard drive, or DVR used to record the data. If the advocate presents the original physical device directly in the courtroom, a Section 63 certificate is not required. However, keeping a primary device in court custody for the duration of a multi-year trial is usually impractical for both the owner and the court. Most practitioners instead use secondary evidence, which includes any copy, printout, or data extracted from the original source such as a CD, a pen drive, or a cloud backup. Under the BSA, the moment data is presented as secondary evidence, it must pass through the Section 63 certification process. Since most digital evidence submitted today is secondary, the Section 63 certificate has become the primary gateway for securing admissibility. Section 63 introduces a standardized template for this certificate, found in the BSA schedule. It splits cleanly into two parts, Part A and Part B. Part A is completed by the litigating party or the person who has physical custody of the device. In this section, the custodian must establish lawful control over the device and provide specific hardware identifiers like IMEI or serial numbers. They must also affirm that the device was operating properly during the ordinary course of business when the record was created. Part B adds a critical technical requirement to the certification process. This part must be signed by an independent technical expert. The law specifies that this person should be an examiner of electronic evidence, as recognized under Section 79A of the Information Technology Act. The expert's role is to verify the technical integrity of the device and the accuracy of the data extraction. This removes the court's total reliance on the custodian's own declarations. This dual certification structure separates physical possession from technical verification, requiring both before the evidence is even considered for admission. The core technical requirement of Part B is the disclosure of the file's hash value. A hash value is a digital fingerprint, RA, calculated by running data through a mathematical algorithm. This algorithm, such as SHA-256, converts raw data into a fixed-length string of characters. Cryptographic hashing ensures that if a single pixel is altered or a single frame is deleted, the file will produce an entirely different alphanumeric string when run through the algorithm again. This helps verify that the data has not been edited, altered, or tampered with through AI or deepfake technology before being presented in court. The resulting string must be recorded on the Section 63 Part B certificate. In court, the judge or the defense can run the file through the exact same algorithm to check if the output matches the string on the certificate. If the strings match, the file is verified as authentic. This turns the question of data integrity into a mathematically verifiable fact. The requirements of Section 63 allow defense advocates to challenge evidence based entirely on how it was collected and recorded. Consider an anti-corruption bureau operation, where data moves from a spy cam to a bureau laptop, and finally, onto a pen drive for the court. Procedural standards require a secure chain of custody from the exact point the data is first extracted. A common error is failing to generate a hash value immediately, only doing so when transferring the file to the final pen drive. This delay leaves the file on the bureau laptop without cryptographic verification. During this window, the data is highly susceptible to manipulation. If the defense identifies this gap in the timeline, They can argue that the original source is compromised. A hash value created days after the recording cannot verify what happened to the file during that delay. A Part A and Part B certificate may be completed perfectly, but they cannot fix evidence if the cryptographic timeline itself is flawed. Sections 64 and 65 enforce the standards set by Section 63 by blocking any alternative methods of proof. If an advocate presents an electronic record without a proper Section 63 certificate, they might try to use general evidence laws to sneak the information in. Section 64 explicitly prevents this, stating that the contents of electronic records must be proved according to Section 63. Another strategy might involve putting a witness on the stand to verbally describe what was in a digital message or email. Section 65 restricts this, stating that oral evidence cannot prove an electronic record's contents unless the record itself is properly certified. If a witness tries to recount a WhatsApp chat without a certified copy of the transcript, the court must strike that testimony from the record. Sections 64 and 65 ensure that electronic records are only proved through the specific mechanisms defined in the Act. The end-to-end process for digital evidence begins with the IT Act, which provides the substantive recognition of the file. From there, the practitioner must meet the strict requirements of the Section 63 schedule, including the custodian declarations in Part A and the expert technical validation in Part B. This process relies entirely on cryptographic verification, a hash value that must be recorded and matched against the file to prove its integrity. The exclusionary nature of Sections 64 and 65 renders evidence completely inadmissible if these procedural steps are ignored. Under the BSA, the admissibility of electronic evidence depends on the mathematical procedure used to secure it, just as much as the content of the data itself. With the rise of deepfakes and advanced AI generation, do you think these new cryptographic rules under the BSA go far enough to prevent data tampering in Indian courts? Or will technical loopholes continue to plague modern trials? Let us know your thoughts in the comments below. If you found this breakdown valuable, give this video a thumbs up, share it with your fellow practitioners, and subscribe to raviklegal for more deep dives into the changing face of Indian law. See you in the next video.